Oyez, oyez, the Superior Court in the Dominion of Canada is now in session. The Honorable Justices Winkler, Akbar Ali, and Lonsdale presiding, all rise.
This matter is Letmano versus Northeastern Ontario Police. Counsel, you may proceed. Thank you.
Pardon? There's a problem with the sound. Oh, maybe it's fixed. I'm just waiting for the sound because it'll echo again if yeah, it's been echoing. There we go.
You know the saying, little Sir Echo, how do you do?
No, I do not, but let's try this again. Okay. Thank you, Justices, and may it please the court. My name is Matthew Dodds, and I am co-counsel for the plaintiff. I, along with my co-counsel Teresa Lindman, will be presenting our arguments for why this court should certify this proposed class proceeding to address the egregious disregard for charter and human rights demonstrated by the defendant on May 28, 2024. The proposed class proceeding meets all of the certification criterion enumerated under subsection 5(1) of the Ontario Class Proceedings Act, and the parties are in agreement that the cause of action criterion is not in dispute. I will be presenting our arguments for why there's an identifiable class and the class definition that we have provided is appropriate, and why the claims raised by class members raise common issues. My co-counsel, Ms. Lindman, will be presenting our arguments for why the proposed class proceeding is the preferable procedure and why Dr. June Letmano is a suitable representative plaintiff. Before proceeding, would the justices like a summary of the facts? No. All right. So now I will present our arguments for why there is an identifiable class. The class is defined as all individuals present at Teddy Talks in Ideas, Ontario on May 28, 2024, who were detained and strip searched by the defendant. The speaksters, the subclass, are all individuals who identify as speaksters who were subjected to the same treatment. These individuals are clearly identifiable via the crimson red chin tattoos that they tattoo onto their face. Now, it is important to note from the outset that there are three rules which govern the definition of a class in a proposed class proceeding. Class definitions are to be objective, they cannot be over or under inclusive, nor can they, and they must be rationally linked to the common issues. If you open your book of authorities to tab 2, page 9, at the top of the page we have cited Bondman v. Ontario. And in paragraph, I'll just give Justice Winkler. Yep, there we go. So in paragraph 264, in defining the persons who have a potential claim against the defendant, there must be a rational relationship between the class, the cause of action, and the common issues, and the class must not be unnecessarily broad or over-inclusive. Also, if you look down to paragraph 265, the class must not also be unnecessarily narrow or under-inclusive. And the class definition that we have proposed meets all of these criteria. The defendant has records of every individual they detained and strip searched at the May 28th protest. If you turn to the defendant motion record, tab 1, Exhibit F, this report by Officer Judy Bigguns indicates that the defendant has a list of all class members who they detained and strip searched on the day in question. Therefore, the class is defined with objective criteria, that is, that they were subjected to detention and search by the defendant. Furthermore,
Sorry, I just was wondering, the class definition that you're proposing requires a strip search and a detention.
correct.
There were people who were detained, as we can see from this list, who were not strip searched. But you are making allegations under Section 9 of the Charter. So is the class not unduly narrow by focusing on the detention and strip searched participants only?
We submit that no, the class is not unduly narrow because the class is defined in particular with a view towards the strip searches. That 350 out of 400 individuals were subjected to strip searches, and these are searches, as I will get into later on in my commonality submissions, that the Supreme Court has held are inherently humiliating and degrading. The fact that all class members share this experience of humiliation and degradation through the strip searches creates a common core for all class members that allows for a sense of clarity. Allows a sense of clarity in the class members' claims.
Does the definition then need to include the words detention at all?
Potentially not. However, we would submit that still there is a question of arbitrary detention that is linked to strip searches, because when you are being strip searched, you are still inherently being detained. If a police officer pulls you into a tent and says, take off your clothes, you're being searched, that is a detention under the law. And I would like to just summarize my submissions here, or conclude my submissions here, by pointing out that the subclass definition also meets the same criteria that I outlined earlier. If you turn to Exhibit B of the defendant motion record, if you look at the bottom at that page, at the bottom paragraph there, you note that there were, so 400 individuals were detained and or strip searched. 350 of the individuals were strip searched, and approximately 200 of them were speaksters. The defendant has noted down in their internal records who was a member of the subclass and who was just a member of the class. In their own internal records, they believed the distinction between class and subclass members was important. Therefore, there is still a bounded subclass met with objective criteria, i.e. identification as a speakster via the crimson red chin, that has a rational connection to the resolution of the legality of these searches. And the legality of these searches is what the case is really about. The class is defined as those who were subjected to detention and strip search, and the core issue at the heart of their claim is whether or not those searches were constitutional pursuant to Sections 8 and Section 9 of the Charter.
Council, just before we move on, does it matter the individual circumstances? For example, does it matter if some of these people were charged and were convicted of these offenses, or is that irrelevant in your submission?
There is no basis in fact on the motion record that any of these individuals were actually arrested. No, there's no proof that a crime has been charged against any of the individuals. But even if that had occurred, that still wouldn't necessarily be fatal to certification at this stage, because it is still open to it is still open at the class certification stage that there are individuals who might not eventually prevail against the defendant, but who are still linked to a resolution of the common issues.
Thank you. Can you also help me with whether or not there's any distinction between the way folks self-identify as Speakstra and the way in which the defendants identified them?
There's no base, that is not on the motion record. These speaksters have a specific dedication to a specific kind of fish that they view as, inherently important in their lives and their nutrition. And to show this dedication to this fish and its farming practices, they tattoo their chins with a red stripe, which means that all members who are subclass members, there is no difference between self-identification and the identification in the defendant's records, because all subclass members do this to their chins. Now, if there are no further questions, I would like to proceed to our arguments on commonality. If you can turn in your book of authorities to tab 3, tab 3, page 19. For the citation from Prosys Consultants Ltd. Versus Microsoft Corporation. And in this case, the common principles of the commonality analysis are elucidated by the court in this case. The commonality question should be approached purposively. An issue will be common only where its resolution is necessary to the resolution of each class member's claim, and it is not essential that class members be identically situated the opposing party. And so we submit that the common issues raised in this case meet these criteria. Particularly, there are 3 common issues that we have proposed. The first is the legality, the constitutionality of the detentions and searches under the Charter. The second is the subclass's discrimination claim that they bring forth under the Human Rights Code. And the third is the entitlement of class and subclass members to damages and the assessment of those damages. I will now turn to our submissions on the questions of the Charter violations. And it is important to note that this court has already certified a class action with very similar facts to this one in the case of Sherry Good versus Toronto Police Services Board. In that case, a superior officer issued an order to subordinate officers to detain anyone within certain portions of Toronto during the G20 protests. This case is very similar. Commissioner Harper ordered her subordinate officers to detain, potentially strip search, anyone who met a series of criteria: acting aggressively, carrying a large bag, possession of Play-Doh, or merely acting suspiciously, all of which are legal activities to varying degrees. You are allowed to carry a large bag to a protest. You are allowed to carry Play-Doh. It is a child's toy. The security context, therefore, undergirding Commissioner Harper's order and all of these detentions is the same for all class members. That is what makes it a common issue for all of them. And there is sufficient basis, in fact, that the defendant's disregard for charter rights can be determined in common. I would like to direct you once again to the defendant in the motion record, tab 1, exhibit F. And there are certain individuals to whom I would like to draw your attention. First, we can look at Johnny Smith, who is the second individual in the chart, who was detained and strip searched, detained for 1.5 hours, just on suspicion of having Play-Doh. We have another individual, Jackson Rockwell, who was detained and strip searched. He was detained for 3 hours in a tent because he had a bulge in his pocket that later turned out to be an apple. If you look at all of the criteria, and then particularly if you flip over the page, actually, and you look at Gil Lemmer and Dr. June Letmano, they were both detained and strip searched merely for possessing a bag. So it is clear that subordinate officers under Commissioner Harper took her criteria as grounds to begin detaining and strip searching individuals who were present at this protest, irrespective of whether or not the grounds enumerated in Operation Play-Doh Stop constituted sufficient grounds to begin detention and strip search. If the justices would turn to the table of authorities again, tab 3, page 24. At the top of the page, we have a quote from the Supreme Court case of R.V. Mann. And in this case, in the first sentence, police officers may detain an individual for investigative purposes if there are reasonable grounds to suspect in all the circumstances that the individual is connected to a particular crime and that such a detention is necessary. We submit that the grounds enumerated in Operation Play-Doh Stop, pursuant to which all of Commissioner Harper's subordinate officers appeared to follow, are not sufficient grounds to justify detention. And therefore, the detentions under them, this is something that all class members share in common.
About the requirement or the criteria of acting suspiciously.
Well, I think it is important to restate again the principle that people are allowed to act suspicious in public. That's not there. What is required is an objective constellation of factors that point to a specific individual, committing a crime. But in this case, all the officers have to go on is Commissioner Harper's order and the same security context. And therefore, the reasonableness of these assessments can be conducted in common because they all arise from the same set of facts at the same protest at the same time at the same day.
If people are detained for acting suspiciously, doesn't that require an individual examination of what they did that was suspicious and whether that justified a detention or search?
So yes, so in theory, yes, that is how that is. The reasonableness of a detention would be assessed, on the individual basis. However, the test is the reasonable person standing in the shoes of the police officer. And it is important to note that therefore the reasonable person standing in the shoes of the police officer in this case would have the same security context in mind as they're engaging in these detentions and searches. And that's what makes, again, that's what makes this common, is that the reasonable person standing in the shoes of the officer would perceive the same security context as crucial to their understanding of why an individual might be detainable in that circumstances.
Counsel, how many different police officers were involved?
That is
Yes.
not on the motion record.
Okay. But if I understand your submission if we're talking about the instructions that were given, but if I just heard your submission, we're taking it from the perspective of the specific officer. Don't we have to, is that not something that we can't assess in common, given the differences of each officer's understanding?
Well, that would be something that we would obviously discuss at a common issues trial, how individual officers understood, the security context as it was playing out. But also what would be, and we would deduce at trial would be, evidence and expert testimony, witness testimony, but was the protest really as bad as the officers perceived it? Just because the officer perceives something to be the case does not necessarily mean that the officer's perceptions are reasonable. And so it is a question about, in the context, were the officer's conceptions reasonable? There are no further questions. Being mindful of my time, I would just like to touch on the particular violations of the strip searches, because as I have said, these are at the heart of this case. So if you can point to your table of authorities, back to the book of authorities that I have provided you, and you go to page 21, 20 and 21. I wish to just identify a few, this is the Supreme Court's holding in R.V. Golden, where, the Supreme Court had laid out a series of controls on the police exercise of conducting a strip search, in order to ensure that there are strong constitutional guardrails to ensure that police officers do not abuse this practice and procedure. And if you look at the bottom of paragraph 59, no person, at the bottom of paragraph 59, no person of the opposite sex who is not a medical practitioner or a nurse shall be present. If you look at paragraph 90, a little bit farther down, strip searches are inherently humiliating and degrading for detainees, regardless of the manner in which they are carried out, and for this reason, they cannot be carried out simply as a matter of routine policy. And then I wish to point you to the plaintiff motion record briefly, Justices. Exhibit J. And here we have a transcript from a protest attendee of unnamed officers that was recorded, shortly after Commissioner Harper issued Operation Plato's. And I wish to draw your attention to unidentified officer 2. Now that Commissioner Harper gave the word, let's hook, line, and sink these freaks. Unidentified officer number 1, replying about the subclass, but indicative of how the defendant treated individuals. All of them should be strip searched, no questions asked. And then unidentified officer 2 replies that they are looking forward to strip searching every single one of them. We submit, Justices, that this recording, on top of a series of other factors, indicates that as the strip searches were applied to class members, as searches must still be reasonable in order for them to be legal, as they were applied to class and subclass members, they were applied unreasonably and therefore unconstitutionally. We have that recording where individual officers were expressing glee at conducting strip searches without any regard for whether or not any individual they were searching had committed criminal activity, whether they had grounds to suspect them. Finally, it indicates a pattern of carrying out these strip searches abusively or for the purposes of potentially humiliating the individual. Finally, as I pointed to you, no individual who is a member of the opposite sex should be present during a strip search, and yet the representative plaintiff was strip searched by a man. And finally, it is important to note that these searches were carried out in public, in tents, where everyone who was getting dragged into a tent knew what was happening to protest attendees. And so there's a disregard for the for the privacy of individuals as they conducted these searches. And that is what makes this issue, the constitutionality of these detentions and searches common, is that the defendant demonstrated a systemic disregard for the constitutional limitations that govern its exercise of search powers in these situations. Being mindful of my time, I just want to briefly summarize the classes and the question of whether aggregate and punitive damages can be certified. Following this court's holding in Good versus Toronto Police Services Board, where aggregate damages were certified as a common issue, or entitlement to aggregate damages was certified as a common issue, this court has held in further actions that aggregate damages are available to plaintiffs for charter breaches, and that is in the Reddick and Brazeau cases, where we're following the holding in Good, aggregate damages are available to classes where there is a shared violation of rights, and that's what we submit has occurred to class members on May 28th, 2024. That concludes my submissions on this matter, if there are no further questions, and I would like to pass it off to my co-counsel, Ms. Lindman, to complete our submissions. Thank you.
Good afternoon, Justices. As stated by my colleague, my name is Teresa Lindman, and I'm co-counsel for the plaintiff. I will be presenting the plaintiff's final two submissions. The first is that the proposed class proceeding is the preferable procedure to address the class member's claims. And the second is that Dr. June Let Me Know is a suitable representative plaintiff. To begin with our preferability analysis, paragraph 51D of the Class Proceedings Act requires a class proceeding be the preferable procedure for the resolution of the common issues in order to be certified. Subsection 51.1 of the Class Proceedings Act further clarifies that a class action will be deemed preferable if the common issues predominate over the individual issues and if a class action is superior to all reasonably available alternatives of determining the class member's entitlement to relief or addressing the defendant's conduct. I will address these requirements in the context of each alternative to a class action, time permitting, those alternatives being individual actions, the remedial offers by Teddy Talks, and complaints before the Human Rights Tribunal of Ontario. To begin, it is our position that common issues predominate over any questions of fact and law that affect only individual class members, such that individual actions would not be a superior, reasonable alternative to this proposed class proceeding. As Justice Perel confirmed in Banman and Ontario, the purpose of ensuring that common issues predominate over individual issues is advancing judicial economy and significantly advancing the claims of the class members with a view of promoting access to justice. So it follows that certification of a class action is preferable if, like in this case, following the resolution of the common issues, claimants are not faced with the same economic and practical hurdles that they face at the outset of the proposed class action. As my co-counsel elaborated, this case, like the certified action in good, involves one order authorizing mass detention, and in this case also strip searching. We say that it follows that determining whether the charter rights of class members were violated requires an investigation into the lawfulness of Commissioner Harper's order and whether the conditions it laid out formed reasonable grounds to detain and search class members. The order and its implementation are the common threads that underlie the class members' claims and relate to the reprehensible conduct they experienced as a collective, predominating over individual issues. So we submit that for all class members following the resolution of our proposed common issues, that their claims will be significantly advanced, and for the majority, they will be resolved.
Counsel, what do you say about damages? Surely that requires an individual assessment. And what's your position on that?
Thank you, Justice. I would like to refer to the case of Good. That's at tab 3 of our condensed book, page 27. So paragraph 73, The second line there, it reads, it would be open to the common issues judge, if the answer to the common issue was affirmative. It would be open to the common issues judge to determine that there was a base amount of damages that any member of the class was entitled to as compensation. It does not require an individual assessment of each person's situation to determine that if anyone is unlawfully detained in the breach of their rights at common law or under Section 9 of the Charter, a minimum award of damages in a certain amount is justified. So we see in an extremely analogous case that an aggregate award of damages is possible. We certainly do not deny that in some specific individual cases that the defendant may have a defense that a class member behaved in such a way as to warrant a detention or a search, like that's possible. But surely this is not the case for such a high volume of class members that a class action would run contrary to the principles of judicial economy and access to justice. The Supreme Court of Canada instructed us in Western that for common issues to predominate, it's not necessary that the resolution of the common issues be determinative of each class member's claim. So we submit that there would be significant judicial economy in determining once and for all class members whether Commissioner Harper's order and its implementation was lawful. And I'd like to remind you, Justices, of the words of this court in Good, that it would be the antithesis of judicial economy to undertake that analysis tens, if not hundreds of times for each individual class member, given the nature of the allegations. And in this case, we're talking about taking that same analysis up to 350 times because that's the size of our proposed class. And turning to access to justice, this court was appropriately concerned about that in Good, a case which involved the detention of about 1,000 people by the Toronto Police Services. Justices, if I could take you to our condensed book at tab 4, page 36. So at tab 4, page 36, at the top of the page, you'll find the Ontario Court of Appeal decision in Good. So they write, more than 5 years after the events at issue occurred, only 16 members of the class have brought individual claims, and 15 of those have been resolved. It remains apparent that most of the affected individuals are unwilling to devote the time and expense necessary to seek individual relief. So, Justices, that's 16 out of 1,000 people. That's less than 2% of the people who had a justiciable claim came forward on an individualized basis. So it's simply not realistic, like this court said in Good, to expect that persons will launch their own proceedings, given the significant economic and practical hurdles that those barriers that face individual plaintiffs when they're considering launching an individual action, given the time and the cost, the difficulty of pursuing justice in our court system. And that is why we say this court would be doing something very useful and practical in approving this motion for certification. If there are no further questions on the preferability of a class action to individual actions, I'd like to turn to the
So just before we leave, so has the law changed in this area? So I hear you in terms of the cases that you cite, but wasn't the law deliberately changed in this area to make this criteria more rigorous? And what do you say about that? How can we apply those earlier cases? Don't we have to filter it through the change in the law?
I think you raise a really important concern, Justice. So the analysis that I took you through was purposely through the lens of Justice Perel in Banman. So to just remind you of the test, Banman was the first case that analyzed what the new predominance analysis following the Ontario Legislature's amendment to the Class Proceedings Act with subsection 5.1.1. And Banman instructs us that we need to look specifically at advancing judicial economy and promoting access to justice with the purpose of ensuring that the common issues predominate over the individual issues. So that's the analysis. And even though we rely on the case of Good because it's analogous, We say that it's not distinguishable because it was decided before the amendment to the Class Proceedings Act, because in effect, they effectively make the same analysis. We see the concerns through their judgment on judicial economy, on access to justice. Those concerns were relevant then in that case, and they're relevant now. If that answers your question.
Thank you.
So turning to the defendant's proposition that class members can rely on the Teddy Talks offers as a reasonable alternative to this proposed proceeding, Justices, if I could direct you to the defendant's motion record. So in the defendant's motion record, if you flip past all of the tabs, A to L, you'll find tab 2. At tab 2, Exhibit A, you should find a letter. And Justices, this is a letter from Teddy Talks to its employees who were detained and or strip searched, and it's an offer for an extra week of vacation. You'll notice at the second paragraph that the first line explains that this offer of 1 week of vacation for Teddy Talks employees is contingent on a class action not being certified. And then if you flip to tab B, you will find the Teddy Talks vouchers for non-employees, $200 worth of food and drink, and then a complimentary voucher for a free ticket to a conference at the Teddy Talks Center. And I'll remind you, Justices, that Teddy Talks is the conference venue that hosted Mr. Anthony Aqua, the controversial politician who was the subject of the May 28th protest. So these two offers constitute the alternative remedial scheme that the defendant has presented. Justices, we say that there are several issues with the Teddy Talks offer. The first is that Teddy Talks is not a party to this case. They're not accused of violating the rights of the class or the subclass. Further, their offers do not address or acknowledge the defendant's conduct, so this alternative does not serve the behavior modification of class actions, which the Supreme Court has told us is important in Hollick at paragraph 27. Further, the offers do not offer any meaningful compensation that flows from a recognition of the defendant's conduct being unlawful. The Supreme Court has instructed in Fisher that for access to justice to be achieved, it requires a real opportunity to recover compensation for all of the losses suffered. This is not a real opportunity to recover compensation for all of the losses suffered. This is a case involving disproportionate police abuse of power. The only people who can answer for the constitutional and human rights alleged violations that we bring here today is the state. It is the police. It's not Teddy Talks. And additionally, I'd like to point to the fact that the offers are not contingent. The offers are contingent on the motion we bring today failing certification. So finding the Teddy Talks offers preferable means that anyone who wishes to pursue their claims against the defendant would have to proceed individually. And the risk that flows from that is that this court could be flooded with individualized plaintiffs when, as my colleague has already submitted, they share substantial issues. I'll move now, if there are no questions, to.
Let me ask one. You referred us earlier to the Court of Appeal in Good, pointing out that very few of the plaintiffs actually commenced claims. And now you're sounding the alarm bell that will be swamped with claims. So which is it?
No, you're right. It's a bit of a double-edged sword. I think the access to justice concern still stands. That perhaps, I think the risk is still there. Our position is that every single one of the class and the subclass members has a justiciable legal claim. If this class action fails, we still want to represent them. It makes more sense to do it, obviously, in a class. That's why we're here today. They still have a claim. The problem is is that they might not bring that claim unless someone goes to bat for them, and especially they might not go to bat for themselves, as we see in Good. So I think the problem, it does go both ways. But the fact that the offers are contingent on the motion we bring today not being certified, like it's a remedial scheme that hinges on people not being able to, assert their rights in a certain way. And again, it doesn't flow from any meaningful compensation. It doesn't serve behavior modification, and it certainly doesn't serve access to justice. Regarding the defendant's other presented alternative that the subclass members can make complaints before the Human Rights Tribunal, the tribunal does not have jurisdiction to adjudicate the charter claims of the subclass members, which leads to a problematic result. And that result is that the class before the Ontario Superior Court, the number of people who have justiciable legal claims there, would not get any smaller. The subclass members all have claims under sections 8 and 9 of the charter. The Human Rights Tribunal lacks jurisdiction to hear violations of charter rights beyond its statutory competencies, and we know that because the tribunal has told us themselves. If I could direct you to tab 4 of our condensed book. So that's tab 4, page 34. At the bottom of the page is a Human Rights Tribunal decision in Al-Turki. So I'll just read, if we could read together the last sentence that's highlighted. The tribunal has no jurisdiction to determine whether there is a violation of an applicant's charter rights unless there is an allegation that the code itself is unconstitutional. In this case, since there's no allegation that a provision of the Human Rights Code is contrary to the Charter, the tribunal lacks jurisdiction to hear the Section 8 and Section 9 charter claims that are so central to this action. If there are no questions on our submissions of the tribunal, I'll move to our final submission about the proposed representative plaintiff. So, Justices, turning to our final submission, we say that Dr. Let Me Know meets the criteria under the Class Proceedings Act to be considered an appropriate representative plaintiff. The Class Proceedings Act requires that the proposed representative plaintiff would fairly and adequately represent the interests of class members, that they have produced a workable plan for the proceeding, and that they do not have, on the common issues, a conflict of interest with the other class members. To begin, there's an argument raised by my friends in their factum that to the effect that because Dr. Let Me Know was compensated $2,000 by class counsel, that she should be disqualified from serving as representative plaintiff. There are several reasons why we submit that this fact should not defeat certification. The first is that it is not illegal for a representative plaintiff to be compensated in this way. Representative plaintiffs play an important role in class action litigation. It involves a time commitment and a responsibility to instruct class counsel through proceedings that could last years. This isn't a frivolous commitment to make, especially not for a busy professional like Dr. June Let Me Know. Second, the payment does not create a conflict on the common issues. It's not contingent on settlement. It does not provide any incentives for the representative plaintiff to act in certain ways that would in any way undermine the interests of the class members. Receiving the money does not change the fact that her commitment and her obligation is to class members. And she has discussed in her affidavit that she understands her obligation to act in their best interests in paragraph 35.
Counsel, part of the record we have before us is that there's a troubling history with respect to your law firm and a troubling history with respect to the integrity of your law firm. And if we put that together with the payment being made to this representative plaintiff, should that not be deeply concerning to this court?
I'll answer your question in two parts. First, there's simply no basis in fact on the motion record that Zach Sockeye induced Dr. Let Me Know to lie under oath in her affidavit. And without that basis in fact, it would be an error to dismiss the representative plaintiff or question the content of Dr. Let Me Know's sworn affidavit or more broadly, her qualifications as representative plaintiff. And then regarding your other concern that, zooming out and examining the landscape in total perhaps paints a scarier picture, I think is the concern you're raising. We say that we need to look at each specific allegation, because I think I can defeat a lot of your concerns if we look at the issues one by one. So again, like my first part of the answer, like there's simply no reason to believe on the motion record that there's a specific issue with the CAS council in this case inappropriately dealing with the representative plaintiff.
I think you invited to deal with the allegations one by one. I'd be pleased to hear that.
Okay, I have 1 minute remaining. I'll do my best. May I have a brief 1 minute indulgence? Okay, so I'd like to speak quickly about the credibility of the evidence that she didn't care about being detained. I think we need to weigh the evidence here. The ex-wife of class counsel does allege that Dr. Let Me Know didn't care much about being detained by the police. We don't know if the ex-wife heard a statement out of context. We don't know how much she was even a party to these conversations, how much she left out. She was there at the house to do the cooking and the cleaning, so we really don't know. But we submit that the evidence that is much more credible is found in Dr. Let Me Know's sworn affidavit, in which she discusses the physical and psychological harm she suffered following her detention and strip search, including physical numbness, panic attacks, flashbacks. Further, it is not uncommon for victims of police misconduct to minimize their experiences, especially in front of others, as a way to cope with trauma. And I'll quickly, with my remaining time,
Your time's expired.
you.
You? Defendant? Your name, please?
My name is Connor Lowes. And together with my co-counsel, Mr. Eric Charters, I represent the defendant, the Northeastern Ontario Police. Pardon me. It is the defendant's position that the conjunctive branches under Section 5 of the CPA have not been met. And it's on that basis that we will ask this court to dismiss this motion for certification. And to that end, we have 4 submissions for you, and I'm going to take you to the table of contents of our factum. Should be right after the first page. In there, you will see underlined the issues at the heart of this case. The first 2, issues A and B on the class definition and the proposed common issues, I will deliver submissions on those. And the balance on C and D, with respect to the suitability of the representative plaintiff and the preferable procedure, will be covered by my co-counsel, Mr. Eric Charters. By way of a brief roadmap, I'm going to first give you a factual overview. I recognize that you have the benefit of the record and also my friend's factual overview. And then I'm going to move to my submissions on class definition very briefly before I move into the heart of the case, the common issues. And there, I'm going to tell you
how the common issues proposed in this case are insurmountably fact-specific to be certifiable. Moving to the factual overview. On one hand, you have speaksters, an environmental group. On the other hand, you have a Mr. Anthony Aqua, who's an environmental expert, elected politician, and working towards the conservation of these speaking sturgeon. The key to understanding what went on at the May 28th protest is understanding what happened at the May 24th conference. And on May 24th, an individual named Sherry Tilapia showed up to the conference and was found and charged with criminal mischief for throwing Play-Doh at Mr. Anthony Aqua.
Well, she was throwing Play-Doh outside and he was inside, right? So she wasn't actually throwing it at him. It wasn't ever going to hit him.
I would agree with you on that. And I think the worry that the police had on May 28th was that there wouldn't be that barrier in between them. With 1,100 protesters, I think that that was the worry that the police were trying to solve. And that brings me really to Operation Play-Doh Stop. But that would require that I slip into common issues. So I'm going to just quickly first address the class definition. My submissions on class definition are very short because they actually come from Chief Justice Winkler himself in the case of Bywater. And I'd like to refer to my friend's Book of Authorities. I'm going to bring you to tab 2, page 11. And I'm going to bring you to the third paragraph from the bottom. And this is from the case of Ragunanen, citing, and I will read it. I agree with Winkler J., as he then was, in Bywater, with the Newburgh class actions, third edition at page 6 to 61, that class actions should be defined in objective terms, and that circular definitions referencing the merits of the claim or subjective characteristics ought to be avoided. Such definitions make it difficult to identify who is a member of the class until the merits have been determined. Justices, that is the problem with the class definition. It's circular and it's merits-based, and it's not objective.
Counsel, can you point me to what the particular circularity is?
Please, absolutely. The circularity comes in the subclass definition, where the plaintiffs propose the criteria for all those seeking a claim under Section 1 as all speaksters who are seeking a claim under Section 1 of the Human Rights Code on the basis of creed. And to address the concerns that Justice Winkler, as he then was, had in Bywater, merits-based definitions erode the class if the common issues are found in the defendant's favor. And in this case, if you find that there was no command order, the whole class dissolves. And that is why the class definition is not certifiable. We know that this was a concern that was in Ragunanen at paragraph 37, but also specifically stated from Bywater, from Mr. Chief Justice Winkler himself. And barring further questions on that point.
I do have one. Defining a class, the jurisprudence tells us, is a technical exercise for the most part. Your friend has made submissions about the identification of people who belong in the subclass based on their chin tattoos. Is that not an objective criteria as to who's in the subclass such that the definition could be technically reworked to avoid the concern you're raising.
That may be the case, but as it stands, it's not certifiable. But I would agree that the plaintiffs have had the rather can make those changes, but in the definition before us today, they haven't.
Would you agree that the court can make those changes on its own motion?
I would agree. And with that, I think it's appropriate to move to the common issues. As I stated earlier, it's the defendant's position that a command order, in this case, is essential for the plaintiff to be successful. And the reason is because in the charter, it's laws that are unlawful. Any unlawful detention will be found to be, or any unjustified, any unauthorized detention will be found automatically to be unlawful. And so therefore, if there's a command order, that any detentions falling under the command order, therefore, automatically mean charter breach. That's why the plaintiff's entire case rests on there being a command order, and they have advanced good BTPS to support this proposition. Rightly so. But I'd like to take you to some paragraphs in good, which my friends have omitted from their table of authorities. Of course, to answer the question of, well, was there a command order, it seems necessary to ask, what is a command order? And command order comes from the case of good. And when we ask, what is a command order, the Court of Appeal in good at paragraph 60 says, the commonality of an alleged command order being made ordering the detention of class members without regard for the individual characteristics or conduct of each class member. It's our position that Operation Plato Stop specifically directed police officers to give regard and to consider the individual characteristics and the conduct of each officer. I'm going to take you to tab 1 of the defendant's motion record, where I hope you will find the affidavit of Commissioner Harper. And I'm going to bring you to paragraph 24. We're going to see what Operation Plato Stop was. What was the order? Reading from paragraph 24, the order from Commissioner Harper was to identify and detain individuals who were behaving aggressively or inappropriately physical with others in the crowd, who were seen with Play-Doh and or large bags, or were behaving suspiciously. That is what the plaintiffs allege is the command order. As we know from the court in good, the case from which command orders derive, it can't be a command order. And we even get further clarification as to why it can't be a command order, almost as if the lower court in good, which was affirmed by the Court of Appeal, predicted this exact factual scenario. I'm going to bring you, or rather I'm going to reference for your notes, the Superior Court case of good at paragraph 28. And they say that the subclasses in good were detained based upon a command order that did not take into account whether there were reasonable grounds to suspect that any of those persons had committed an offense. Rather, the persons in the subclasses were detained simply because they were part of a large group who had congregated in a particular area of the city. And this is where I think a factual comparison between good and the case here is helpful. In good, the reason there was a command order is because the officer said, police, go to the gymnasium, and everybody you see in the gym, they're all detained. You are to walk in and let them know that all of them are detained simply because they're in the gymnasium. No regard to individual circumstances, no regard to individual conduct. In this case, police officers were instructed to go and identify people based on the grounds which generally equate to the already existing reasonable suspicion power that we get from Grant. And I want to address something that my friend has said. About acting suspiciously. And my friend's words were, it's not illegal to act suspicious. And perhaps that's fair. However, the detainment powers of police officers are not considered in a vacuum. And please don't take my word for it. If you find my submissions at paragraph 26 of our factum, I can perhaps read them for you if that's expedient. But it talks about how the actions of a person, this reasonable suspicion, is to be considered in light of the totality of circumstances. And we know that because the Supreme Court told us that in the Crown and Jacques. So it's not just that people are allowed to act suspicious. If the suspicion that the police officers are concerned about is holding Play-Doh in a crowd of 1,100 people who potentially also have Play-Doh, 4 days after somebody was arrested and charged with mischief for throwing that Play-Doh, and after an anonymous tip was received by the police that there was going to be another incident of Play-Doh throwing.
Council, we've heard a lot about the merits of the police's position, and is not the central teaching that we have that this is not a merits assessment. We look, it's a procedural motion. We look at whether or not the litigation is sort of putting forward something that is technically correct. Can you help me with how these submissions relate back to that central question of commonality? Isn't this a merits pitch you're giving me?
I have two answers for that. First, the reason it's so muddled with what's merits and what isn't is from the nature of the class definition that the plaintiffs have put forward. Second, and perhaps stronger answer, comes really from the direct wording in Bandman and Stolov. From Bandman, they're both the same sentence. Bandman cites it at paragraph 277 and Stolov at paragraph 349, that an issue is not a common issue if its resolution is dependent upon individual findings of fact that would have to be made for each class member. That's why there's no commonality here, because the detentions which occurred are inherently individual fact-finding exercises that would need to occur. And we can't have that.
Could you then address the transcript that's at tab J of your friend's record, where we have the two unidentified officers seemingly preparing to strip search people because they have the chin tattoos, which doesn't seem to comport with any of the three criteria that have been laid out, if we even just sort of ignore for a minute what behaving suspiciously might mean.
The first point that I'm going to make on that is that my friends have raised an evidentiary concern with the statement of Nancy Nark being not credible because it wasn't there to have verified. And my co-counsel has further submissions on that and how it relates to this double hearsay statement recording, which we're talking about. But my answer to your question about, but it seems like it wasn't just these three grounds from Commissioner Harper. The interpretation of the police officers of what Commissioner Harper said, it's wrong. It's just wrong. The recording is not what Commissioner Harper said. You have her words in front of you of what she said, both at paragraph 24 of her affidavit, sworn under oath, and in her notes taken concurrently on the day of. These two police officers can't amount to anything more than bad apples, and it's our position that we can't certify a class action based on bad apples. Two people who misinterpreted. And regardless, factually, this case is different than Good in terms of how the alleged command order was played out. But in Good, it was, if you are in this gym, you are detained. Or if it were at this protest, if you are at this protest, you are all detained. Our class size wouldn't be 350, it would be 1,100. Because in this case, the officers were instructed to do something that the officers in Good were not instructed to do. And that was to give specific consideration to the individual circumstances of each class member. And I know that that maybe dips into merits in some sense, but that's the whole problem here, is that it's an inherently, the class definition is inherently reliant on merits, and whether or not there is a command order is absolutely central to the case. And we know from good the case that the command order came from, that it's not what happened here. I want to address, before I notice that my time is slowly creeping up on me, and I'd like to just address another concern that my friend raised. And when I heard it, it was delivered to you during an examination of their Book of Authorities, and I'd like to return back to their Book of Authorities. And if you'd like, rather, if you may, if it pleases the court to turn to tab 3, page 21 of their Table of Authorities from the plaintiff. I'm looking at paragraph 59. Tab 3 and page 21. They talked about expressing the concern of the strip searches and how egregious they were, and they point you to this authority, and they say, in addition, no person of the opposite sex who is not a medical practitioner or nurse shall be present. And they told you how Dr. June Letmino was, in fact, searched by a male. And of course, when a brief look at this citation from my friends, it seems to indicate that that's a very big concern. But I'm going to bring you to the top of this same paragraph, where it says an intimate search under the PACE is an analogous to a body cavity search. This paragraph is about body cavity searches. That's not what happened here. We had strip searches. There were no basis, in fact, to suggest that any of them were body cavity searches. I just wanted to clarify that quickly before that was left with this court.
Okay, you have 1 minute left.
Thank you, Justice. To conclude, the class definition, from the words written in Bywater by Justice Winkler, as he then was, tells us the concerns about merit-based, non-objective definitions. Those same concerns exist here. My friends have alleged that there was a command order, and as a result, all detentions and searches flowing from that order are unlawful and therefore illegal. But this can't be the case because of the case that the command order came from itself, from good. They tell us that that can't happen here. And my time is elapsed, so barring any further questions from the justices, thank you for your time, and I'll leave it to my co-counsel to conclude the balance of our submissions.
Thank you very much, counsel.
May it please the court. My name is Eric Charters, and I will be concluding submissions on behalf of the Northeastern Ontario Police. I have 3 primary submissions for you this afternoon. First, a class action here would not be manageable due to the predominance of individual inquiries over any common issues. Second,
Could I ask you just to pull your mic a little closer, please?
is this better, Mr. Chief Justice?
Yes, it is. Thank you.
Thank you. So first, a class action would not be manageable due to the predominance of individual inquiries over any common issues. Second, reasonable alternatives exist in conjunction with which better serve access to justice while being at least as good for behavior modification and judicial economy. And third, the proposed representative plaintiff and her litigation plan do not meet the requirements for certification under Section 51E of the Class Proceedings Act. With respect to the predominance of individual issues, our friends would have us do the analysis in reverse. They say the shared experience of a strip search is really at the heart of this case, but that comes at the end of a long chain of inquiries. Because if there's actually anything to litigate, what they're really trying to say is the shared experience of an illegal strip search. There's nothing to litigate over a legal strip search. And that's linked to the reasonableness of their detention, and that's linked to the suspicion under which they were detained. They would have you answer that question in common with a command order, like in Good. As my co-counsel has pointed out, Good is an order which points to a group of people and says, detain all of these people. We don't know who they are. Maybe there's someone standing in the middle of that group who's done nothing wrong, who couldn't have done anything wrong. We don't know. We couldn't identify any of them. And that's just not what's going on here. Our friends took you to the incident report of Officer Judy Big Guns, and I'd like to take you back there. You can find it at the defendant's motion record, Exhibit F of tab 1. While you're finding it, for some context, Officer Big Guns was assigned to manage one of the tents. She did intake for other officers, bringing protesters to that tent. This is clarified in paragraph 29 of Commissioner Harper's affidavit. So these individuals weren't detained by Judy Big Guns. This is just a summary. And what does the summary show? Well, 3 lines down, Craig Johnson. Reason for police interaction? Attempted to throw Play-Doh at police officer. Interaction with police? Near violent altercation. Was this person detained under Operation Play-Doh Stop? Or was this person detained because he attempted to assault a police officer with a very weapon that was at issue in this case? The latter is probably the better answer. We have to conduct an examination of the evidence to find out. We need to find out what officer detained him. We need to get their notes. We need to hear testimony from that officer. What was the basis of Craig Johnson's detention? And we have to repeat this same analysis 349 times for every prospective class member. Because unlike in Good, we don't have a basis to say everyone was detained under the order. So from the very beginning, we need to know if the order even applied to these people, even if you find that the order exists. And this is the distinction at the heart of the case. This is what makes it unmanageable. And this is why there are better procedures. Justice Perel pointed us to these better procedures in a case called Stolov, a companion case to Banman, essentially. They were based on very similar facts. Both cases, Banman and Stolov, were about inpatients, at mental health care facilities, and about the treatment of those detainees within the facilities. Justice Perel certifies Banman, and then, a short time later, doesn't certify Stolov. What's the difference? Well, in Banman, there were 2 programs, the PST program and the MAP program. These created frameworks under which people dealt with problematic, if I may be excused for the term, inpatients. And the treatment to which they were subjected were governed by these programs. So we have some basis for commonality. In Stolov, no such programs were put before the court. And so Justice Perel denies certification and says, we can do a joinder action here. If people claim that they have significant breaches, there are advantages for a joinder action over a class action. He points out a previous case, Spencer, in which the proposed plaintiffs would have saved themselves 2 decades of motions and procedural wrangling had they merely proceeded by joinder from the very beginning. And of course, this isn't really a problem with judicial economy, because anyone who's going to engage in a joinder action are going to be those same people who end up in individual issues trials at the end of any proposed class action. We've saved all the time in between, so it's better for judicial economy. And it's much better for access to justice. I looked it up this morning on my way to court. On Canley, 455 cases say justice delayed is justice denied. And that's the point here. Folks with compensatory claims for significant damages can join all of those claims together and get to those individual trials far earlier without the procedural wrangling of a class action. This is the point that was missing from my friend's previous submissions on our alternatives. Our friend suggested to you that we suggested the Teddy Talks vouchers and vacation offer as an alternative remedy sort of out in the air on its own, and that's not at all what we're suggesting. We're suggesting anyone who has a compensatory claim, go do a joinder action. You don't bind the rights of anybody who doesn't. Those who have a claim for breach, non-compensatory breach, who are seeking damages, like we see in the cases of Reddock and Stewart, just damages for the fact of the breach itself, those damages are very small. And in those particular cases, it was $500 a head. We have some more recent jurisprudence that might increase that to $1,000. Let's call it $1,000. Let's say everybody wants to make a claim for this de minimis breach. Okay, that's $350,000. Now, our friends take issue with the idea that this relief, the Teddy Talks alternative, comes from a third party. They say, well, that doesn't modify behavior. I agree, but neither does $350,000 to a large regional police department. That's not what modifies behavior. What modifies behavior is the weight of the court's judgment finding any breaches. And that's why in Stolov, Justice Perel said that joinder was just as good for behavior modification as a class action in that kind of case. And that kind of case is this kind of case. It's a case where there are potentially small numbers. Our friends pointed us to good. 16 people sought relief. Presumably they were seeking relief for compensatory damages. So maybe a small number of people, maybe it's 16, maybe it's 20. I'm sure class counsel will offer them the same contingency arrangements he offered June Lemino, can join together and advance those compensatory claims. And they won't bind the others from seeking a financial remedy tomorrow. They can walk out as soon as this course dismisses the certification motion and obtain some financial compensation through the Teddy Talks relief, while waiting for the court to pronounce any judgment on any breaches that they would wait even longer for in a class action than a joinder. That's why it's a wash on behavior modification. It's a wash on vindication. It's probably better on judicial economy because it's less time, and it's far better on access to justice for the same reason. Now, my friends perhaps didn't quite think through the fact that these two alternatives were offered in conjunction. Maybe that's because they didn't receive any guidance, help, or input from a disinterested representative plaintiff who didn't think through things either. And that brings me to my submissions on 5.1e, that June Letmino is not a suitable representative plaintiff because she's disinterested in the litigation. She's nothing more than a placeholder plaintiff created to serve the interests of class counsel. So we know that from the statement on Nancy Nark, and I do need to just take a moment and depart from the overall structure of the submissions to point out a real tension in what you've heard from our friends today. On the one hand, Nancy Nark's statement, there's a signature on it. There's a warning about the penalties, criminal penalties, for making false statements to police. And she tells us in no uncertain terms, June Letmino was not particularly bothered by being detained by police. And Mr. Sakai offered her $2,000. All of a sudden, her mind changes. They take issue with that particular statement. We'll put a pin on it and come back to it in a second. At the same time, they put before you this phone recording, this transcript from Donna King's cell phone recording. So we have a hearsay transcript Of a hearsay recording, why the recording isn't before the court is totally unaddressed. Of a hearsay conversation between two unidentified and unidentifiable officers, and the content of that is yet another hearsay statement about what Commissioner Harper may have said, or perhaps how they interpreted Commissioner Harper. Is this document admissible? Undoubtedly so. But it doesn't provide a basis in fact. That's the difference. That standard's always a little vague, right? And this is a good illustration of it. When we leave 51A in a certification motion, we leave from the realms of bald allegations. Here's the allegations. Are they a cause of action? Great. That's not contested here. We move on into a realm where we require some basis in fact. It's an evidentiary standard. What basis in fact is provided by that document? It doesn't.
So there is some jurisprudence that talks about things like newspaper articles and all of that being admissible to meet the some basis in fact test, despite the fact that they're hearsay, because they are an indication of the kind of evidence that a plaintiff may be able to adduce. Does not this transcript and the fact that this conversation was overheard by somebody suggest that that is the kind of evidence that the plaintiff could adduce in a common issues trial?
Justice Akbarali, a newspaper article is much more similar to the Nancy Nark statement than it is to the Donna King cell phone recording. A newspaper article is written by an identifiable journalist, someone compellable to testify. We can figure out how it is that they got the information that they had. It's often direct reporting. We don't end up with this sort of double or triple anonymous hearsay problem that we have here, where there's no basis for any further lines of inquiry about this recording. It has to stand as it is. We can't find out who said it. We can't find out anything about the context. We don't even have the advantage of the tone and intonation of their conversation because the recording, for some reason, was not put before the court. That's it. It's all we get. I put to you that the difference between that piece of evidence and a bald allegation is not really any difference at all, and illustrates exactly what we mean by something that fails to rise to the level of some basis in fact.
But don't we, sorry, apologize, counsel, but don't we have to take into account that plaintiffs haven't had discovery yet? They're just here. This is what they have been able to put before the court prior to discovery. If we certify this action, won't you have to go and put this for your evidentiary record forward on this? You'll have to disclose what you have?
Yes, Justice Lonsdale, but there's no suggestion that we have anything on this particular conversation. It was obtained by a third party who's not a member of the Northeastern Ontario Police. It was obtained in the context of a bathroom conversation. It was recorded on a cell phone. There's nothing to suggest we would have anything on this particular conversation.
I guess, am I getting this rightly or wrongly, that your proposition is that whatever this purported evidence is, to constitute a basis in fact, it would have to rise to the level of being a basis in fact. Is that what you're saying?
Yes, Justice Winkler. Yes. And so they want to have it both ways. And they want to dispute the payment of $2,000 while at the same time arguing that there's not really anything wrong with it. But in fact, this payment of $2,000 is the gateway that starts to illustrate all of the issues with June Letmino as a representative plaintiff. It reminds us that she and Zach Sockeye are friends. They have a previous relationship. It reminds us that she wasn't particularly interested in the class action, in the problems that they say lead to this class action, until she was offered this inducement. Justice Strathy, as he then was, analyzed exactly this type of problem in Singer at paragraphs 221 to 222, and said that the close relationship between class counsel and the representative plaintiff, coupled with a lack of desire to address a real injury, ruled that representative plaintiff out. Like Chartrand put it, the role for which she was recruited was a passive one. She's a tool for class counsel, and they're in the driver's seat. It's supposed to be the other way around. This is further illustrated by her lack of knowledge of any of the issues in the case prior to her affidavit. A few days before, she was cross-examined. You can find the transcript of that cross-examination at tab 1 of the defendant's motion record, Exhibit K. Let's go there now. It starts off reasonably well. Ms. Let Me Know, are you aware of the causes of action in this case? Of course, we're suing the police. And that's pretty much the last thing that she's clear on. She doesn't know what Section 8 of the Charter was. Do you know what it protects against? No idea. You're not aware that it protects against unreasonable search and seizure? Nope. She says she has some knowledge that she has a right not to be searched. She's not clear on what is going on here. It gets even worse as we go on. Do you know that the claim contains a claim for damages for breach of Section 9? No. What is that? Do you know that Section 9 protects against arbitrary detainment? No. She's aware of the existence of the speaksters, but if we turn the page over, she's not aware they're bringing a discrimination claim. She's not aware that they're raising it on the basis of creed. She really has no idea what's going on. And we're not suggesting she should be able to provide some sort of legal analysis here, but it feeds into this same picture of someone who started off very disinterested in the case, had to be induced by class counsel in order to become involved in the case, and is really content to let her lawyer take the driver's seat. This ends up having real consequences when we think about the litigation plan that's put before this court for certification. Perhaps the starkest of those consequences is the notice period that they suggest should apply here. They want to give 10 days notice, and they want to let the class know about this through an advertisement in a local newspaper and a website. Presumably, no one would know about the existence of the website unless they read the advertisement in the local newspaper. But at paragraph 3 of her affidavit, June Letmano tells us she has an international clientele for her dermatology practice. Why does she have an international clientele? Because of her use of speaking sturgeon. Would it not occur to an interested person that perhaps some of these international people might have been among the protesters there on May 28th? Is it not at least worth asking the question? And especially, there's a very obvious person to ask. My friend indicated in his submissions that the police have, quote, the defendant has records of every individual present on May 28th, end quote. He referred to this as a list. If anybody was paying attention, wouldn't they have asked the police who the detainees were, how we might get in touch with them, involved us in some way in the notification period? But no one was paying attention because Ms. Letmano was recruited by class counsel, not the reverse. For those reasons, this court should dismiss the plaintiff's motion for certification. Thank you, Justices.
Thank you, counsel. Reply.
We would not like to exercise our right of reply. Thank you.
Thank you. We'll retire and be back shortly. Thank you.